So this is a question that has been asked, I think, about 8 times in the Facebook group this week alone. So we thought we need a video about this because this is a top question. We're also getting tons of questions about it at consultations. So when your fiance petition, your I-129F is pending, or your I-130 is pending, are you allowed to visit the United States just as a visitor, with your fiance or your spouse while that's pending? And obviously, this is a huge question. People have been separated for a long time. The cases are taking a very long time to process. And in order to be able to live with the processing times that we're currently seeing in many cases of over a year, many people are just trying to figure out, okay, how can I actually see my the person I love? I don't want to be separated physically that long. So this is sort of a multi-part answer. There's a little bit of nuance here, which I know is sometimes difficult to explain, but I'm going to do my best to explain kind of the different main scenarios we see and what would apply to you specifically. So the first thing you have to understand about immigration is that there are 2 types of intentions that you can have legally when you enter the United States. There's something called immigrant intent, and then there's non-immigrant intent. So immigrant intent is when you are, got your bags, you're showing up at the airport, you're moving to America, you're staying, you want to live and work here indefinitely. That's you have the intent of an immigrant to become, essentially an immigrant to America. And non-immigrant intent is when you're coming to the U.S. To do something specific, like you want to visit Disney World, or you want to go to college, or you want to just visit and go on vacation, or visit some relatives or something like that, or maybe you have a temporary job or something like that. So there are many categories of non-immigrant intent, or many types of non-immigrant intent, but the basic concept is that you're coming for a specific purpose and you're intending to leave the United States. So why does this matter? What does this have anything to do with what we're talking about? Well, the question gets a little bit tricky when we're talking about situations where people are already filing as fiancés or spouses of U.S. citizens, because in general, if you are married to a U.S. citizen or you're engaged to a U.S. citizen and you've already filed documentation with the U.S. government saying, hey, I intend to permanently move to the United States, in some ways you've expressed that you have immigrant intent, right? Because you've actually said, I plan to move to the United States. But so that doesn't necessarily mean that you cannot visit. It just makes it harder, and it makes it a little bit riskier. So what is allowed is if you have filed for a fiance case or a spouse case and it's pending, you can have the intent to, okay, when my fiance visa case is completed or when my spouse visa case is completed, at that point, I'm going to have immigrant intent to move to the United States. But for now, I have non-immigrant intent to visit in the meantime. So you see how those 2 things can coexist, right? That's possible that you just, this time on vacation, but yes, I do have a long-term plan to immigrate to the United States. So yes, people typically who are either doing a fiance visa or a spouse visa, they can visit the United States if they have a way to do so. And if the officer that inspects them at the border or at the airport believes them that they have non-immigrant intent on this visit. So it's definitely possible that you get off the plane, you go through customs, and the customs officer says, well, I just don't believe that you're going to leave after 3 weeks or 2 months or whatever you've planned, to stay. I think you're going to just try to stay here. And so it's possible that they can turn you back for that reason. As long as you're not lying to them, that's not typically going to hurt your fiance visa or your spouse visa. It just means you couldn't visit while that's pending. So that's very possible. It is difficult for some people. So hopefully this is all kind of making sense to you guys. This is like a long answer one, but I know everyone wanted to know, so we had to make a video for it. But one thing I want to point out is that for people from a lot of countries, it's just hard to visit the United States anyway. So if you happen to be from a country that is, in a typically pretty good position economically, your country might participate in the visa waiver program, which means that basically, if you don't have a serious criminal history, you can fill out the ESTA documents and you can just visit the US for 90 days in most cases. So those are typically the people who can come and visit, or if you already have a tourist visa. If you're from a country that you can't get in on visa waiver, you don't have a tourist visa, you can try applying for a tourist visa, but those are typically denied when you try for a tourist visa from a country that has a high rate of overstays of tourist visas. A lot of countries in Latin America or just less developed areas of the world where the government the US government is suspicious that you'll probably want to stay rather than going back home, just because a lot of people from your country have done that in the past, then you might not be able to visit simply because you don't have a way to get any kind of non-immigrant permission to come and visit while you're waiting for your case, and you just simply have to wait. So you can see why this is such a complicated situation. There's one more thing I definitely want to mention, and that is that sometimes people asking this question are in the United States and they're applying for adjustment of status. So they have an I-130, but they've also applied for a green card at the same time. And they cannot leave the United States and go abroad and come back unless they have advanced parole, which is like a travel permit, people would call it. Until you have that temporary travel authorization, if you leave, you're going to abandon your case entirely and have to start over outside of the United States. So sometimes that issue kind of gets rolled in there too. And I just want to make sure that if you're listening to this and that's your situation, please know that that does not mean that you are allowed to travel while that's pending. So every situation is very different. Hopefully that gives you all some more perspective on that question. And I'm just trying to get the truth out there as usual for some of these important topics. So you guys can visit each other.